Joining me now is our newsmaker at the moment, someone who's been advising Rahul Gandhi, senior advocate and Congress MP, Abhishek Manu Singhvi. Abhishek Manu Singhvi, how do you respond to what the Surat court has said? There are no exceptional circumstances that merited the conviction being stayed. They're saying Rahul Gandhi as an MP should have been far more careful with his words. Why not simply apologize, which perhaps would be the way to settle this once and for all, Dr. Singhvi?
Rajdeep, just examine what you are saying and you'll get the answer there. First and foremost, he should have been more careful with his words is not a domain which arises before the learned sessions judge. It's one of the errors. There is a conviction by a magistrate. The main appeal is pending before the sessions court. This is only an interim proceeding that should the conviction be stayed till then. It is only on the interim. So it's not a final trial. Now, for such time...
Why doesn't your client just apologize and end this matter?
Why should he apologize? He's done nothing wrong. Why should he apologize? Why should the solution be for him to admit defamation and apologize? Why should the solution not be for you to ask that when you ask the question, why should there be no stay of conviction? Is it a murder charge he's facing? It's the mildest of charges. 2 years sentence max. Is it a Prevention of Corruption Act charge he's facing? Then what else is the test for stay of conviction? When the learned judge says that I should not give him a stay of conviction, what else will be a more appropriate case? A, no murder charge. B, no corruption charge. It's a case of a conviction on first appeal. The first appeal will test the conviction. In the meanwhile, which can be a more stronger case that you should not lose your seat in parliament, suspend your conviction, allow you to sit. Mr. Sidhu was given a stay of conviction on a murder charge. There are 7 cases cited by the learned judge himself in the first 7 pages, by himself, underlined by the learned judge, which show that conviction has been stayed for corruption charges. Now, this is the shortest possible reason why he should get this. It is not a conviction finally. It's only that suppose tomorrow his appeal is allowed. Rajdeep, consider the balance of convenience. Tomorrow, after 3 months, 4 months, Rahul Gandhi wins his appeal. Can you restore to him the days in parliament he has lost? Part of the last session and part of the oncoming monsoon session. So what is the point of saying there is no irreparable prejudice? So I am not here to argue the case before you. I am saying there are lots and lots of strong grounds, patent errors on which the High Court will be approached. And meanwhile, let me tell you, in fact, it is reflective of the BJP's clear fear and attempt to throttle his voice.
No, one minute. Dr. Singhvi, how is this BJP's attempt to throttle his voice? We've got to look at these as 2 distinct issues. There's a court proceeding going on, and there is the natural parliamentary fallout of what has happened. Once you get convicted for 2 years or more, you lose your membership. So we've got to distinguish the two. Are you suggesting to me that in some way what has been happening in the lower courts is influenced by the BJP?
Let me explain to you straight away. You have a political battle, fight it in a political discourse. Do you fight a political battle by getting 3 of your persons having the surname Modi in Ranchi, Patna and Surat file defamation cases? Is it not an attempt to harass? Is it not an attempt to intimidate? Is it not an attempt to silence your voice? You come back from abroad and you make an extraordinary precondition that Mr. Rajdeep, unless you first apologize, I won't allow you to speak in parliament. Have you ever heard of this? You say another condition that, look, I will give you privilege notices. I, as the ruling party, will disrupt parliament and not allow you to speak. I won't allow you to have a discussion on the corruption charges or the crony capitalist charges you are raising. I will first say that you apologize and then only will have that discussion. Now, are these not all attempts to stifle and silence his voice? That's the point I'm making.
No, the point I am asking you is what the court said today. The judge said powers accorded under section 389(1) of CRPC to suspend, stay the conviction is required to be exercised with caution and inspection. If such power is exercised in a casual and mechanical manner, the same will have serious impact on the public perception on justice delivery systems.
Rajdeep, it's very interesting you're reading this. It is precisely what you're reading which is the error. Read the first 7. Now, we have shifted from politics to law. Let's stick to law for just 2 minutes. The first 7 or 8 pages which you are holding in your hand are only quotations from judgments. Have you noticed the lines underlined by the judge? He has underlined those lines to deny Rahul Gandhi stay of conviction. The lines say the opposite. One of the cases you are holding in your hand is Serene's case.
Yes.
It says it's a case of corruption and therefore serious, don't stay it. Second case you are holding in your hand, the very lines you are reading, is Sidhu's case. And the judge has underlined the lines. There was a murder charge where in fact it was stated. What the judge has done is he cited case law in principle without applying it to the facts of Rahul Gandhi's case and without noticing the stark contrast between what you are reading and Rahul Gandhi's case.
So you are drawing, correct me for our viewers, you are drawing a distinction between a criminal defamation case, which you believe does not merit 2 years in the first instance, versus someone who has faced a murder charge. Am I correct?
Forget 2 years, but yes, there is a vast difference between a corruption charge, a murder charge and a defamation charge. It is made out from the very cases which the learned judge has cited in the first 7 pages which you are holding in your hand. He has underlined those lines without noticing that is actually underlining a contrast in favor of Rahul Gandhi. What he is doing is he is underlining those cases which underline a contrast in favor of Rahul Gandhi. That's the error of the judgment.
Can I therefore ask you in conclusion, presumably you are going in appeal. Last time you took 10 days to appeal. Questions were raised as to the delay. Are you going in appeal right away now to the High Court?
There is absolutely no reason for delay, but there is no reason for hyper urgency, as we are being advised by all and sundry, by internet lawyers and WhatsApp lawyers. I mean,
forget internet lawyers, WhatsApp lawyers. What are you going to do? Are you going tomorrow morning to the High Court or not?
I'll tell you. Of course we are going. We will make a properly drafted appeal. Parliament is not in session immediately, so we have some time. And the appeal will be filed shortly, and thereafter it will be brought up the subsequent week or whatever when the matter is listed in the court. It's as simple as that. I have never understood. You know, the last time the actual filing of the appeal took place after 8 to 9 days. I was very amused to see on your channels so-called people saying I would have drafted in 3 hours and filed it, 6 hours and filed it. I found it very amusing.
Okay.
I mean, hats off to them if they can file an appeal on a Gujarati judgment in 9 hours. I hate to talk about the quality of that appeal. Anyway, the point is that please don't advise us when to file our appeal, how to file our appeal. I think that much we know. But yes, in the very proximate future, you will have an appeal.
Okay. We'll leave it there, Dr. Singhvi. We'll get back to you when and as and when that appeal is filed. We don't want a running ball-by-ball commentary. We just wanted to enlighten our viewers, and that's what you've done. I appreciate your joining us. Thank you very much, Dr. Abhishek Manu Singhvi there, who remains the Congress's legal eagle.